advisory opinion on the use of nuclear weapons previously cited by our chairman, the international law, including international humanitarian law, applies to any weapon. The rules relating to the use of force and how force may be applied during conflict do not change because a particular weapon is employed. This is as true of armed drones, cyber weapons, and autonomous so-called killer robots as it was to any weapon previously developed in our arsenal. While these new technologies pose some specific challenges to the application of existing rules and perhaps call for the formulation of some new rules, they are by no means incompatible with the existing legal frameworks which we know and have developed over so long a period of time. It is largely a question of creative adaptation of the existing rules and, where necessary, formulating new rules to fit the situations posed by the new weapons that are being developed and have been developed. And there are a growing number of authoritative restatements of the law and policy papers, positions by governments and by academic institutions, which set out, and in my view, at least partially succeed in doing so. I can name a couple of them. The Air and Missile Warfare Manual, developed by a group of experts under the auspices of the Harvard Research Project, HCPCR, codified, if you like, or restated the law for air and missile warfare, which has never previously been written down. The recently published Tallinn Manual, which I had the privilege to work on the application of international law to cyber warfare, attempts to do the same thing with regard to digital warfare. And the results of both of those studies indicate that it is perfectly possible to apply existing law and adapt the existing law to new weapons like armed drones, like cyber weapons and computer network attacks. As for the challenge posed by the proliferation of legal norms coming from different backgrounds or different areas of international law, if you go to a conference these days, often you will see kind of trench warfare emerge between IHL lawyers on one side of the room and human rights lawyers on the other side, to give one example. This is all, in my view, completely misguided. The fact that new areas of, or existing areas of law which have not previously been applied to military operations, particularly during armed conflict, are now considered to apply to them, does not pose any real threat to IHL, nor does it, in my view, pose a real threat to the unity of the legal system, as long as well-tried and established methods of legal interpretation are employed in a rational and coherent way to give full effect to all relevant provisions of the law and to give precedence to particular provisions of the law where that would be required under the circumstances. The so-called lex specialis principle referred to in the nuclear weapons advisory opinion is not a carte blanche to ignore human rights law. It is a specific reference to IHL in a particular context of conduct of hostilities. So it is, in my view, perfectly capable and possible to adapt these rules in a coherent way and provide legal guidance that can be of help, and in fact of invaluable help to any commander deployed on any type of military operation. Another development in this area is the development of what is referred to broadly as military operational law. And what military operational law attempts to do is bring both a horizontal and a vertical translation of abstract legal norms into things like rules of engagement, instructions and aide memoires to the commander, and so forth. In other words, usable legal guidance for the military commander in the field under conditions of combat. And that has become a well-accepted and well-tried instrument that is used in armed forces throughout the world, in United Nations peacekeeping operations, and in other types of military operations. So I see no insurmountable challenge posed by the fact that many different types of law can apply during armed conflict. Turning finally to the problems posed by contemporary postmodern asymmetric warfare between, on the one hand, state armed forces and various types of armed groups. Sometimes this is primarily in internal armed conflicts, but sometimes he can spill over into neighboring states. Now, one of the things that we have to realize is that while reciprocity has a role to play in promoting legal observance, especially in a horizontal legal system like international law, it is not a condition for observing the law, and it cannot be an excuse for shortcutting one's obligations. This is a fundamental principle which is in a slightly different form has long laid at the foundation of IHL. The fact that one side has the right to use force under the law governing the use of force, the jus ad bellum, contained in the UN Charter, and on the other hand, and the other side might be engaged in aggression, has never served as an excuse for not observing the international humanitarian law rules relating to conduct of hostilities and respect for persons who are vulnerable in the armed conflict, such as prisoners and civilians in occupied territory. Those who violate the law can and should be held to account and punished in conformity with the law, but violation of the law by one side is not a get-out-of-jail-free card for the other side. Secondly, while it is a legal requirement to apply IHL to any armed conflict, it is equally important to do so in a way which is in accordance with the scope of its applicability and to do so consistently and in conformity with other legal obligations under international law. The selective application of IHL by, for example, applying the law relating to the conduct of hostilities but ignoring the rules that relate to treatment of captured persons is not the way in which asymmetric warfare can be effectively countered. In fact, it usually boomerangs to the advantage of the side that is seen as being the victim of the violation by the state. An example of that, of course, is all the negative fallout the United States has received over its treatment of detainees in Guantanamo Bay and elsewhere. There are no easy solutions to these problems posed by asymmetric warfare. And sometimes you will see civilians routinely and even deliberately attacked. Their cultural monuments and basic religious values and so forth being attacked as being part of the target. Examples of that can be seen on television regularly lately with the march of the Islamic State in northern Iraq. These attacks on the dignity and cultural values of peoples and even threats of genocide are unfortunate part of the asymmetric warfare that seems to be a part of modern day society. Part of the solution can lie in increasing awareness of the law where the reason for its violation lies in ignorance. In some cases, it may be possible and appropriate to extend the protection of the law by judicious application of amnesty for regular fighters in a non-international armed conflict to enable a long-lasting peace to be agreed to. Right now, the Colombian government and the FARC rebel movement are engaged, in fact, trying to reach some kind of agreement where some degree of amnesty would be applied to the regular fighters who had not violated basic human rights or IHL standards. This could be a way forward without prejudice to the ultimate right of any state to insist on observance of its law and constitutional order. Finally, some problems can be addressed by improved enforcement of the law of war, and this is an area which perhaps is most needed improvement. None of these in themselves or in concert will succeed in altogether removing the causes of such violations in these type of conflicts, or even their existence, and the indiscriminate violence which sometimes or even often accompanies them. Actually, this ultimately lies outside the province of international humanitarian law. The deeper-rooted causes of armed conflict and inequality are not addressed in international humanitarian law. They are a problem that is much broader and much more complicated than simply applying the Geneva and Hague Conventions. They can only be met by good governance, promotion of human rights and dignity and equality of all under a well-functioning legal system to remove the underlying causes. Now I will conclude. Ladies and gentlemen, I hope I have been able to offer you some convincing arguments relating to the universal nature and long-standing origins of international humanitarian law, and some ideas on how the current challenges it faces can be addressed. While these challenges are real and require ongoing and continuous attention, they are neither as novel nor as sometimes as supposed incapable of being resolved as sometimes is argued by people. The answer, in my view, lies in a consistent and coherent application of the existing legal framework and adapting the existing legal framework to those new challenges I mentioned where that is required. It is a good faith operation, in other words, an action of applying all relevant law in a way which makes sense both in terms of legal observance and in terms of being able to be realistically applied in the kind of conditions that IHL is meant to cover. I have great confidence that meetings such as this help promote the values underlying IHL and other related disciplines of international law, and I'm happy and honored to have been invited to provide a contribution to the further discussion and dissemination of this fundamentally important and continually relevant area of the law. I thank you all for your kind attention.